Good morning. This is Rich Sierra with the Florida Small Business Legal Center. This is episode number 10 of Business SOS podcast. We're very excited that you're here with us this morning or afternoon, whenever you're listening to the show. This will be a part 2 of the episode number 8 that I did 2 weeks ago. And it was the importance of understanding a basic contract law. So this is kind of a part 2 of that, and we're going to talk about that a little bit today. As I remind you, I'd like you to participate in the show, and I'm very excited that last week I got an email from one of our listeners that basically asked me for when I did the partnership disputes episode a few weeks ago, somebody took me up on the offer. And I said, if you send me just an email and you would like to have the questionnaire that I use for my clients when developing partnership agreements and or operating agreements, I'm happy to send it to you for listening to me this morning. And I received an inquiry and I sent that agreement to that questionnaire to the listeners. So I want to thank you very much for participating. What I'd like to do is also as well, if you have a legal question that you would like me to cover in my show, please just send it to me at richsierra.com. And if I select your question, I will not mention your name. I just basically address that particular issue. I'll go ahead and send you a free copy of my book, autograph, and I'll send it to you. So make sure that when you send me your information, include your address so we can send a copy of the book as well. So 2 weeks ago, I talked about the importance of understanding basic contract law. And I think that just to recap what I said 2 weeks ago, is that it's important for business owners to have an understanding of the type of contracts that you're signing. And some of them might be routine contracts. For example, and I give the example of a restaurant that have on a weekly basis, they buy inventory for their restaurant, and they have a purchase order. They sign it. They acknowledge the receipt of the goods. They agree to pay. That is a contract. And they're the contracts that are not as routine, but just as important. And an example of that is a lease agreement that you basically sign maybe every 3 to 5 years, and you don't see them again. You don't see it again until the renewal time period or when the option to renew becomes available at the time you're going to terminate the lease. So there's some contracts that you as a business owner are going to be facing throughout your journey as a business owner that some of them are routine, daily or weekly, and some of them are a little bit longer term. But it's important for you to understand when you're actually entering into a contract. And so that episode is number 8. I want you to, if you have any questions, go back and review it as well, because I really give you a lot of good information as to, listen, this is a contract, what am I signing? And remember my rule in contracts, if you do not understand the contract, do not sign the contract. Get professional assistance, get an attorney to help you interpret the contract, especially when the contract is written by an attorney. You are already at a disadvantage if you're not an attorney yourself. So you want to go ahead and level the playing field to have an attorney review that for you who understands business contracts. So again, you want to basically level the playing field when reviewing contracts. So today I want to talk about breach of contract. What happens if there's a breach of the contract? And a good portion of my practice during the last 18 years have been when parties breach a contract. Usually somebody comes to my office and said, I have this contract, and I'll give you an example of a buy-sell agreement. Somebody bought a business, and it's very common that when the seller sells a business to the buyer, the seller agrees not to compete in the similar business in a similar geographic area. So that's just one example of one of the provisions that is very common in buy-sell agreements. And in the future, I'm going to do a segment on, and probably will be the next one that I'll do, is I want to buy a business, what should I do? So I'm going to go over some details on that. But today I want to talk about just a couple of examples of breaches of contracts and understanding what is a breach understanding what is material breach and understanding when you need to basically perhaps seek legal intervention to enforce your rights under the contract. So in the example that I gave you, say a seller, has selling a pizza restaurant, for example, and the seller agrees not to open a pizza restaurant within the 5-mile radius because it has delivery and it has a brand. So you go ahead and basically come to my office and say, listen, I just go ahead and I bought this business 2 years ago, and the seller basically opened another restaurant within 4 miles from my location, and I still owe him money. Usually, say a promissory note of say $50,000. What should I do? Should I continue paying this promissory note? So that's a very common example that I see here that I face, on a weekly basis in terms of potential breaches. So let's talk about what is a breach. The first thing that I ask, basically, I need a copy of the contracts. I need a copy of all the closing documents. So I look at the contracts, I look at what the contract states, because at the end of the day, that's what we're going to live with. And it's very important that to make sure that if there's a term in the contract a term that you agreed upon verbally, and it is an important term that gets included within the written contract, within the written agreement. The reason is, this is the reason why you need to do that, is because when there's a breach, sometimes maybe a year later or 2 years later, and the parties who are involved in developing that contract with you may not be around. They might move. They may not be doing the same business. They're just not available. So when an attorney looks at the contract, say, okay, I need to look at the documents first and then compare what happened, what you're telling me that occurred with what the contract states. So we'll go ahead and basically look at the contract. In this pizza restaurant example that I'm giving you, the contract stipulates, yes, you know what? The seller agrees not to open a pizza restaurant within the 5-mile radius. It's clearly stated there. Then the buyer finds out, my client, that he's opening an Italian restaurant, but he also serves pizza within 4-mile radius. So there's the nuance. That's where basically we're going to find out whether it's real competition or not, and what is the effect, and what are the damages. So obviously the buyer is upset because he's invested all this money into his business, and then finding out that the seller is basically now competing against him. So we'll look at the first thing. Let's go at the obligations of the parties. What are the parties' obligations? You have here a situation where the buyer is perceiving that the seller breached the contract, and the buyer is still paying a promissory note. This particular case, the example that I'm giving is $50,000, so it's a 2-year note, approximately $2,500 a month that he's been paying. So he does not want to pay the note, and he would say, I want to go out and sue. I want to basically send a cease and desist, and I want to get an injunction. And I said, okay, but let's talk about that. So I look at the contract, and it clearly states that, and I said, okay, what are the damages? So when you look at a breach of contract, you got to find out, okay, yes, there could be a breach of the contract, but what are the damages? Okay, in that particular location that you are in this example that I'm giving, okay, how much business are you getting from that particular area to quantify the damages? So when you look at a breach of contract, you have to basically prove that, yes, you had a contract established, there was a material breach of the terms, and number 3 is damages. So in this example, my client tells me, you know what, most of my clients are coming from a 3-mile radius. In fact, most of them are coming maybe from 3.5. I don't see too many clients coming from that 5-mile radius. Maybe 2 or 3 a month come from that area. And, I basically get their email addresses, zip code. I try to get them to my email list, get information. And so I'm not sure how much damages I'm getting, but it might not be that much. That's okay. You still breached the contract, but the damages might not be that much. So that's one example. The other example is like, you know what? My delivery area, I'm delivering pizzas, basically all the way back to 6 miles. So I get a lot of business from that particular location. There's some really great neighborhoods in that area. And by him opening a restaurant there, it's going to affect my business. So that is a material breach, and there's damages that can be quantified. So what happens in this case? So the approach is usually, and what we try to do first is try to mitigate the damages. We send usually a pre-suit demand letter. It's usually common in these cases. Very seldom, and I have not seen that very often, that someone decides to go straight from a material breach straight to the lawsuit simply because there's an opportunity to get it resolved before then. So we send a cease and desist letter with a copy of the actual contract, the obligations, and in some cases we actually include a draft of the lawsuit and draft of the preliminary injunction, motion for preliminary injunction that will be filed if we're not able to resolve this amicably before then. So we send this letter out. Obviously the seller gets, upset, and then by receiving a letter from an attorney, and he said, no, I'm not going to have a pizza restaurant. It's an Italian-style restaurant, and we're not going to deliver, but we're going to have pizza will be in the menu, but it's not going to be a delivery type service. So we look at the contract, and the contract does not specify what type of pizza restaurant the seller cannot have. It's very broad. And that's why important, if you remember my episode in number 8 about clarity in contracts. So if you have in this particular case, a non-competition agreement, so you can have in some of them we use boilerplate languages, which I'm not very, very fond of, that says, you cannot compete directly or indirectly with the type of business that we have, but that's very broad. You got to basically state specifically what is the business that you cannot compete against, because otherwise it'll be difficult to enforce. So in this example, the seller's attorney obviously calls and say, there's a misunderstanding here. Yes, he's going to be opening a restaurant, but it's not a pizza delivery service restaurant. It's not a to-go service. It's just pizza is part of the menu, but it's not going to be the major source of revenue for that business. So it's going to be difficult to quantify the potential damages. And that's a valid point. However, the non-compete specifically states you cannot open a pizza restaurant. So what do you do in these cases? You can go full force and try to say, I'm going to file a preliminary injunction. I'm going to go ahead and get the court to basically put an injunction and stop this particular seller from opening this restaurant. That requires significant amount of monetary commitment, and there's no guarantees that the court would agree to that. Or you can negotiate a potential settlement. So a number of options that we have here. In this example, the buyer owes money to the seller. The buyer basically says $50,000 note, and the seller technically breached. If you're selling pizza restaurant within a 4-mile radius, if he has then he breached the contract. But we will have a difficult time proving the actual damages that the buyer, in this particular case, my client, would suffer. Because then you have to have an expert quantify, the number of pizzas were sold in a particular period and this particular restaurant. Then you have to look at how many pizzas would have been sold in this particular area of this restaurant. Are they really competing? You have to compare menus. And if you recall a prior episode talking about litigation, that there's a tremendous amount of cost involved in litigation improving your day in court. So you have an issue of if you want to have a preliminary hearing, a preliminary motion hearing, that is like a mini trial. And there are different standards to meet that, and I know I'm going kind of on a tangent here, but just for this example, you basically have to, the buyer's going to make a decision whether or not he wants to go through a mini trial to present to the judge evidence that, yes, he will be damaged if this restaurant would open with irreparably harmed if this restaurant opened, and he's likely to succeed in the merits. Those are the standards for a preliminary injunction. And there are no guarantees that the court would agree to that. But there's also another point to that. So even if the court agrees to basically prevent the seller from opening this restaurant, the court can impose a bond on my client and said, okay, I'll grant that motion, but we're going to post a bond. Should you lose the case, that bond is going to be used to pay the seller's attorney's fees. So there's always a double-edged sword here when you go to court because you don't know what's going to happen. So in this case, the clients, they can basically negotiate. And the majority of the time when you have a breach of contract case, a lot of times it's because of misinterpretation of the obligations of the parties. In some cases, there's a breach because the promises that were made in the contract were not fulfilled, or the parties are unable to fulfill the contract. So there are a number of reasons why contracts are breached. That's why clarity in contracts is extremely important. So in this particular case, the parties can do a mediation, which I spoke about it previously, and try to negotiate a potential settlement. In this particular case, a potential settlement could look like this. Said, okay, you would agree, the buyer can agree to, you can have your restaurant, okay, however, you're not going to offer delivery service. That's one. So that way, whoever wants to, no Uber Eats, no, any of the services that offer delivery, you're not going to have a delivery service. If people want to basically pick up the food, that's fine. But number two, we're going to reduce the amount of the note that we owe you. We're going to modify the non-compete agreement in such a way that if that's just what you want to do, that's fine. However, you're not going to, we're going to reduce the note to say for $25,000. In fact, maybe $50,000. We'll just wipe out whatever we owe you. That could be a potential settlement. But also we can have a provision said if anybody calls you to go, to order a pizza to go, you refer them to us. So there are a number of different ways that you can solve a potential business dispute, but that's just one example of how it can be resolved. That you can be creative, and you can solve it as business owners versus allowing the court to make, or the judge, in this case, to make a decision for you that in most cases, neither side is happy when the judge makes a decision for the business owners. Business owners like to be in control. Business owners like to be creative. There are many disagreements that go along the way. And so that's just one example that I'm a big proponent of mediation for that reason, because business owners like to solve problems. In another example, there are cases that you have to go to court, that you might not have a choice to go to court. And an example, let's say, following this example, say, for example, we send a cease and desist letter to the seller to not open the restaurant, and the seller does not respond, ignores the letter, And came to find out that when the letter was the lawsuit, then you have to basically file a lawsuit. Came to find out it was not him who was actually opening this particular restaurant. It was his son who was doing it. He was helping him. That in itself is indirectly breaching the contract because you're assisting somebody to breach the contract, giving your intellectual property, you're giving them your know-how, your knowledge base to compete against the buyer who basically you sold the business to. So a lot of people do this to try to circumvent the spirit of the contract, and it's still not a good idea. So in some cases, when people think they can breach a contract and they can get away with it, they might try it. But you still, in that case, you might have to go to court to enforce your rights. How do you do that? You got to make a determination. And when you have a contract that you're signing, and I'm kind of going over some of the material that I went last time, you have to think, if this contract, if the other side breaches the contract, how am I going to enforce it? Number one, how can I enforce it? How can I enforce my right, protect my rights? And you have to say, how much money is going to take me to do this? Because litigation, especially business litigation, is a battle of resources. And you have to make that determination that just because it is in writing, just because somebody will promise something to do in the contract or something, or promise to not to do something in the contract, does not mean they will follow it. But if you do not have the resources to enforce the contract, you might have a problem. Because if you don't have the money to basically pay the attorney to take the case to court, to do the negotiations, to issue the proper legal threats that go along the way, that are required to compel the other side to get back in line with the terms of the contract, you're not going to have a chance. You have to be able to think, if the other side does not follow, how am I going to enforce it? So those are the things you got to consider, and how much it's going to cost you in the long term. And we talked about attorney's fees before, and I'll talk about it again because I think it's important. Many contracts have provisions for attorney's fees. And when I look at that, a client say, yeah, you know what, if we win, the other side will pay your attorney's fees. And I say, okay, just because that provision, that could be true. But in order for you to obtain attorney's fees on a breach of contract claim, in Florida, there are two ways. A statutory claim, like if you're filing a lawsuit under the Florida Deceptive Trade and Unfair and Trade Practices Act, is one example, or civil theft claim. And number two is when you have a provision in the contract that says prevailing party attorney's fees provision. So if you don't have that, those provisions, each party pays their own attorney's fees. When you have the attorney's fee provision, what it means is the following. It means that at the end of the case, when everything is done, after appeals, you have the right to ask the court to award you attorney's fees provided pursuant to the provisions of the contract. And it's up to the court to agree to grant us attorney's fees for you, and also would agree to, and the court to determine whether they're reasonable attorney's fees. So just because the provision is there, and many business owners make this mistake, they say, that's fine, I have attorney's fees provision there, we're going to get attorney's fees anyway, go ahead and do the case, quote unquote, do it up front, and you'll get your money at the end. That is just not realistic. And it's not financially feasible for most attorneys to do that. And I'm not talking about contingency fee cases like you have in personal injury. It's a different conversation altogether. The But when you're talking about attorney's fees provision, it means that you have to pay that up front and hope to recover that at the end, on the back end. That's what it means, that you're entitled to ask for them. Doesn't mean that automatically you're going to receive them. So I want to make you clear that. But you have to think when you look at a breach of contract claim or a contract that you're about to sign, okay, if I need to enforce this contract, can I do it? And you might say, you know what, I might not be able to do it, but I'll take my chances. The reality is, in most contracts, people go into with good intentions, and unless something goes, wrong or there's a misunderstanding along the way, for the most part, you're not going to see. It's not very common to see breach of a contract. I see it because that's what I do for a living. But for the most part, every contract has a duty, good faith, and fair dealing. So if people go with good intentions, there's clarity in the contracts. For the most part, it's going to be okay. But you got to follow your instincts here, who you're dealing with, and the terms. And also the amount of risk that you're taking with each contract. Because every contract has a certain amount of risk. It's a promise. It's a promise that I'll do something for you, I'll receive something from you, and we hope that it works out. But there are no guarantees. Just because in the contracts, no guarantees that it's going to basically happen just as it is written. So just keep that in mind as you're looking at various contracts. Give you a couple of extra points before I wrap up. And I think some of the contracts that I believe that you should keep track of, you should basically be aware of, that are very important to have and know every single term. Certainly a partnership agreement that you have with your partner. Those, I see a lot of partnership disputes coming my way. And it's because the terms of the contracts, number one, they don't have a contract. Or number two, there are no terms in the contract about the obligations and limitations that each partner has as to what to do with the business. And that's where you have a lot of misunderstandings. So it is important to have that clarity. Lease agreements are also very important to understand each term. And if in one of my first episodes, I talk about lease agreements, and they're really for the benefit of the landlord. However, as a tenant, especially I'm talking about commercial leases here, as a tenant, you do have certain rights. But at the same time, you have to understand their provisions, each provision of the contract. So those are two contracts that I want you to pay close attention to. Employment agreements, obviously, very important. Independent contractor agreements, if you have them. Every contract, and now non-compete agreements, and I know that they may go away in the future, but important to know them as well. And understanding when there's a breach, and if there's a breach of the contract, my advice to you is not to overreact. Don't start sending nasty emails. Don't start, just take a deep breath. Pull the contract, contact an attorney, know the facts, get the facts straight, and sometimes with a phone call, with an email, with a letter, it can be resolved before going straight to a litigation matter that then it escalates. And also, if you make any type of agreement after the fact, it's important to put it in writing. And I just give you an example of that, is that sometimes in this example, sometimes people with good intentions, and the pizza example that I gave you, that the seller could say, you know what, I told him that I was going to open a restaurant. I told him I was going to do this. You say, no, I never heard of that. So that becomes kind of a question on who said what. So it is important that if there's any type of agreement or understanding after the contracts are signed, that there's something that memorializes those terms to avoid these disputes. Just to recap, in my experience, a lot of breach of contract claims comes from misunderstanding on the terms of the contract. Misunderstanding out of the obligations of each party. And it comes perhaps because the inability of one party to perform. And in very rare cases, it's because one party just does not care and wants to breach the contract anyway. It doesn't ever happen very often, but it does happen. And those usually, unfortunately, are the cases that end up in court because at that point, it is a willful material breach. It is not necessarily one that was done because of a misunderstanding or misinterpretation. It was because somebody just didn't care. It does happen. If you have any questions about contracts, breach of contracts, any of the terms that I talked about today, please send me your question at rich@richsierra.com. I'm happy to address any questions that you may have. I'm happy to send you an email back with your question, but also I'd like to address that in the show and, educate our listeners. I can talk to a breach of contract pretty much. I can do the whole episode on that, the whole podcast, but there's a lot of areas that I want to cover. And remember, I'm talking to these concepts. They're not necessarily legal advice for your situation. Every situation is different. If you have a takeaway here, it's like understand when you have a contract in front of you, understand, yes, do I understand the terms? Understand my obligations? Understand the other party's obligations? How is it going to terminate? What happens if it breaches? And what risks you're taking? And then you decide whether or not you want to sign it. If somebody breaches the contract, go back to those terms and find out exactly what was breached or violated in that contract, and what are the damages? What monetary damages do you suffer as a result of that material breach? Do not overreact. Pick up the phone, call an attorney, have the consultation, and see how it can be resolved so you can move on before going into the litigation mode. So how can you reach me? I said my email, rich@richsierra.com. If you're interested in learning more about our legal services, our website is floridasmallbusinesslegalcenter.com. We're on Facebook at FSB Legal. This podcast is also being, we have a video on this, so you would like to watch the video instead of listening, go to youtube.com/@Richard Sierra. We're on Twitter at Rich_Sierra. We have an Instagram page. It's FSB Legal. You can call us at 866-842-5202. Also, Business SOS, 8 common legal mistakes business owners make and how to avoid them. It's available on Amazon, Barnes & Noble, or you can ask for it at your local bookstores. If you like the podcast, please follow us. We also ask you to give us a review. And you can share it also with your friends, your colleagues, if this information you want to share with them. We're on Apple Podcasts, Spotify, or wherever you enjoy your shows. Until next week, this is Rich Sierra with the Florida Small Business Legal Center. And remember that my goal is to help you succeed.